very good morning, all of you. Last year, probably November, I had been to here, and I find that most of the places are going to be. Now today, I feel myself very happy and pleased that I once again have come here and shared my ideas about firstly about the safeguards in criminal jurisprudence, constitutional safeguard in criminal jurisprudence. And next, there are two judgments which recently delivered. One is old, that is the Kumar, and two others. So on that issue, what was the concept of bail they have considered, that I will share you in a second. With the constitutional safeguards, right? So, if you look at chapter 3 of our constitution, you will essentially find 3 articles which actually covering the field of providing safeguards to in criminal jurisprudence. The first is Article 20. It is said that no person shall be convicted for any offence except for violation of a law in force at the time of commission of the act charged as an offence, nor be subjected to penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. The two key words here you just take note of that the conviction, violation of law in force at the time of the commission of the charge, and penalty greater than what might have been inflicted under the law in first time at the commission of the offence. So, therefore, I am sharing you few provisions, may I first tell you what the first part is dealing with. First part is dealing with what was not an offence on a particular time, right? But there was something done which fulfilled the basic ingredients of that offence. But what I say, that mean to say that that offence is created subsequently. Say for today, from today a law is enacted and certain acts have been made to be an offence. But someone is found to have committed that offence, fulfilling the ingredients about a year back. Now he cannot be prosecuted and tried and then convicted for that offence. The first example I find 498A of the Indian Penal Code. It came into effect from 24th of December 2083. So what is this? It is the IPC. To the wife by the husband or any one of the members of his husband's family by demanding or torturing her on inflicting torture on the demand of dowry and other things. Therefore, it came into effect on 25th of December 1980. If we find that one X in October 1983 also assaulted or inflicted torture on his wife on demand of dowry. So now he cannot be, because that was in October. On December, on that time 498 was not in the statutes book. It is came into effect from 25th of December. Therefore, whatever previously done, for that the husband can or any one of the members of his family cannot be prosecuted, convicted, or be sentenced for that offence. I think that I am clear on that. There are several other offences that you know that after the Nirbhaya's case, there are certain changes are made and new provisions have been brought into the Indian Penal Code. These are 354A, 354B, right, and 354C, 354D, and 326, that is acid attack, and 326A. It was previously 326 and 326A has been introduced, which is attempt to acid attack. Right. Therefore, whatever you just there he is bringing the book. No? 1 minute then, let the book. Just now I referred. Okay. Section 498A of the Indian Penal Code. What I said that it is, you know, all of you, I don't need to repeat it. So, what in concise that these provisions came into effect on 25th October, December 1983. Right. So, therefore, before that, in October, if any husband or any relative subjected the woman to cruelty on demand of dowry, so for that, the persons who committed that offence in October cannot be prosecuted and tried and convicted and sentenced. Similarly, there are other provisions. After Nirbhaya's case, there are certain changes that have been brought in the Indian Penal Code. Those are previously 354 was there, 354, that is outrage of modesty. Now, it was already in the statutes book, 354. Now, there are other provisions, 354A, then 354B, 354C, 354D. These are the provisions which is has been brought into the statutes book on and from 3rd of February 2013. Therefore, according to this constitutional safeguard which is provided in Article 20 and Subarticle 1, for anything done like this manner, no person can be tried or convicted or sentenced if it was done prior to 3rd of February 2013. This is the long and short of this protection. It has two parts. Another part is this, that not to be subjected to a punishment greater than that which might have been inflicted under the law in force at the time of the commission of the offence. Now again, you see there are certain offences. That is, let me start with that if you have the old book, then you will find that there was gang rape was defined in 376, that is in the explanation, it is said what is gang rape, and the penal provisions was 376 2G. Right? And punishment prescribed what not less than 10 years to life imprisonment and fine. Now there is a separate provisions. That particular 376 2G have been deleted. Now it is 376D. Right? The same thing. The definition of offence has not been changed. Only it was brought under separate sections, and the punishment prescribed is not less than 10 years to life imprisonment. That is reasonable to meet, and the other things, reimbursement and fine to the victim, that is reasonable to meet the medical expenses. So therefore, whoever was committed gang rape before 3rd of February 2013, he has to be tried on a charge under section 376 2G, not under 376D, but on and from 3rd of February 2013 he should be tried under 376D. So therefore, the same offence earlier has the punishment not less than 10 years to life imprisonment. Now it is converted to minimum sentence of 20 years and then life imprisonment plus fine to give the medical expenses to the victim. And clear? Similarly, if we find that the rape upon judicial separated wife, that previously it was 376A, now it is 376B. Earlier punishment was maximum 2 years imprisonment and fine. Now minimum punishment punishable with 2 years to 7 years and fine. And minimum punishment not less than 2 years. But previously maximum punishment was 2 years. Previously that section was 376A, now it is 376B. Sorry, I first said that it is 376A now. It is now 376B. Similarly, there are other offences under the 376, and then in 326A has been introduced. This is there are several offences. In those, the offences were previously under the same offences under 376, under the heading of 376. Now that have been made different categories are brought under different as capital A, capital B, capital C, capital D. Only the change is this, not in the definition or basic ingredients of the offence, but change is only introduced so far as the sentence. So now the sentence is more, but whoever committed this offence before 3rd of February 2013, they cannot be if the trial has already commenced, because the trial of the sentence is to be determined on the basis of the date of commission of the offence. That is what is very much clear from the constitutional provisions that have been implemented at the time of commission of the offence. At the time of commission of the offence, it was say for 10 years, now it has been enhanced 20 years and 2 life imprisonment. Therefore, the person cannot be sentenced to 20 years. Maybe that on the date the judgment is delivered, the punishment is 20 years, but on the date of commission of the offence, it was 10 years. So this is the basic idea about that. Now, other thing is this: no person shall be prosecuted and punished for the same offence more than once. That is sub-article 3. So what is that? Suppose a person is prosecuted when the trial is going on, it was found, it was challenged in the High Court that there is no sanction. So it is said without sanction that prosecution cannot commence. Naturally, court declared it is null and void. So case is false. Now the sanction was, however, the liberty was given to the prosecution to obtain fresh sanction and to proceed. Prosecution obtained sanction and the trial was commenced. The question is this, whether somebody may raise the question that I was tried and the trial was declared to be null and void. So how for the second time I will be tried for the same offence? But according to the several decisions of the apex court, and it is no decision is necessary, because that prosecuted not only to be prosecuted and punished, but in those cases what I am referring to, there this accused was prosecuted and trial was going on, but no conviction, no sentence. Before that it was terminated. That is the reason. Suppose in one case a person is convicted. So after convicted, he went to the court set aside the order of conviction and remanded back the matter to the trial court for retrial. So a question may arise that earlier I have been faced a trial, I was convicted, and then again I have been sentenced. Now, after setting aside the order of conviction sentence, you are sending it back to the trial court for retrial. Whether the impediment under section 320 sub-article 2 will be attracted. Although this is the same offence. Maybe charge under 302 X charge for killing A. So I am clear. Do you have any queries? Right. Next is this: no person accused of any offence shall be compelled to be a witness against him. Suppose you have the section 40 of the FERA, that is the summons is issued and that particular person is called for examination. He has not yet been an accused. Suppose that you see that decision that 2012, that is that where the first time it is said about the preliminary inquiry. I can't just recollect that. Can you tell me that decisions that there should be a preliminary inquiry in that in some offences where that was below 7 years, and then only after preliminary inquiry the police find that there are sufficient material, then the case will be registered and the investigation shall be proceeded. So I don't remember that case. So as I am referring to 40 of the FERA, 108 of the Customs Act, and say for example 160 of the CRPC. You see that what is that information in cognizable cases, the qualifying words in 154, and 153 information as to non-cognizable of cases and investigation of such cases. So here an order from the magistrate is required. And if you see 156(3), 56 article subsection 3, that is also any magistrate under section 190 may order such an investigation as above mentioned. Any officer in police may, without order of magistrate, investigation. That say that any officer, so order of a court is not required. To start, without the order, that is, it is the any officer in charge of police station may, without the order of the magistrate, investigate any cognizable case. And then, if he not refuse to register the FIR, the remedy available to the complainant is to either to send a complaint to the SP, senior officers, and or to move the court and get an order under 156(3). Why I was telling all these things is this, that unless one person is made accused in a particular case, so he is not protected under Article 3 of sub-article 3 of Article 20. That no person accused of any shall be compelled to be witness against him. Now, two things. One is section 93 of the CRPC. Another is section 94 of the CRPC. Just look into it. Madam, can you bring your book with annotation of the CRPC? Issuing notice or summons. Section 93 deals with issuance of search warrant. Section 93, when search warrant may be issued. Now, this issue came up before the Honorable Apex Court in one Shamlal case. This was as far back as in the year 1965. So, where Supreme Court dealt with the issue. No, sorry, it was in the case of Uttar in 1980. Samlal is a different case. Search warrant. So it is said that in the search warrant, if it is said that police is, you come to the schedule and take what is the format of the search warrant. I think that you are aware about it because every time you are issuing in many occasions search warrant. Suppose it is, what is the in the form number 11, that is the form of the search warrant. Here it is only, you see that form number 10 and form number 11 only specified the place, not the accused. If while issuing the search warrant, if you specify the accused, who is already accused, maybe in custody, except section 27 of the Evidence Act, that is a different, no question of search warrant. So that will hit by section article 20 of article 3. Because you see everywhere that is a place. Maybe that on searching of that place, many incriminating articles could have been recovered. But thing is this, that if he specified the person, then it will attract, not otherwise. Similarly, other provisions is section 94. No, sorry, this is 91. The summons to produce document or other things. This is the no court can issue, it is settled position that no court can issue summons for productions of documents, directing the accused for producing the documents, or police also cannot issue the notice for these purposes. The first part of the constitutional safeguard, that is under Article 20. I think that I have been let you know what, and I believe that you all of you know that. Just I was reminding you that this is the provisions. I am sure that all of you know that, right? So now we are coming to Article 21. Article 21 has a wide expansion. If you consider if you get the bail, any decision of apex court, on several occasions and quite frequently they are referring about the personal liberty. So that while you are considering the bail, question of bail, you have to remember that this is something that relates to your personal liberty. That is 21 is the another limb of protection, safeguard. Last one is Article 22. What is Article 22? This protection against, and one thing I may refer, that whatever that according to Article 21, that no person shall be deprived from his personal, from his life and personal liberty. So according to the Supreme Court, when you are arrested, taken into the arrest, and as you know, according to the position of law, he is losing his personal liberty. Therefore, it will attract 21, and you can do it by following the procedure established by the law. The fundamental right is this, and you notice, I think that you have noticed that all these provisions in chapter 3, there are few provisions. It starts with a citizen of India. Say for example, that 15, Article 15, no citizen shall. Equality 16, no citizen shall. But if you carefully looked into these provisions of Article 19, you will see that no citizen shall. 19 is very vital provisions, but if you look at Article 20, there is no reference about the citizens. 21, no reference of citizens. 22, no reference of citizens. Then therefore you tell me that what do you understand by looking at these provisions? Please tell me.
Basic human rights.
No. Once again I am saying that all these other provisions in 19, 16, 15, all are qualifying with the words no citizen. But when we come to Article 20, Article 21 and 22, there is no such reference.
Because these are actually available even to non-citizens.
Yes.
And
Suppose in case of Aslam Kasab, so he was not a citizen of India, but in case of him, these three provisions are available. So this is the very essential distinction between these things. This is one of the safeguards. This is because whenever a person, whether he is a citizen of India or a non-citizen of India, these protection safeguards will attract. Therefore, in my opinion, amongst all the provisions in the article in chapter 3, these three are very important provisions, and this is how we make the distinctions. Right? I am clear? Okay. Then in section 20, in article 22, what is said? Another thing, that article 21, it is said that no person shall be deprived of his life and liberty except in accordance with law. Suppose a person is arrested. So in the CRPC, it is said that this is a cognizable offence. Police arrest him. So it is according to the procedure established by the law. Suppose the offence is bailable offence, but in a case of non-cognizable offence, police arrest a person. Police has no power without the order of the magistrate. Therefore, this is not in accordance with the procedure established by the law. Therefore, it will hit by this article 21. Similarly, if a person is arrested in connection with the bailable offence, police will not release him from the jail. He will forward the accused to you. Now you will decide whether he should be granted bail or not. But if the person is committed an offence which is a non-bailable, right? So I had the occasion to have a case when I was a judge, because I had the occasion to deal with the case while I was an advocate, that one person was arrested for commission of the non-bailable offence, a bailable offence. Therefore, according to the law, and if you follow article 21, then it is the duty of the police to tell him that you are arrested with this offence, right? And at the same time, you are entitled to bail. If you are ready to furnish bail, I will release you. He cannot be detained. But normal practice, what I have seen in Calcutta, police are arresting the person for commission of the non-bailable offence and detained him, and on the next day, the accused is challaned to the court. And he immediately get bail because offences is non-bailable. But in one matter, a question arose that this is whether his detention was illegal or not. So, actually to decide the case, I was of the opinion that police must record in the GD that this person who was, we received a complaint. In the complaint, there are allegations of commission of the offences, although cognizable but bailable, and he was arrested around this time. He was brought to the police station, and he has been brought to the police station, and he has been apprised that this is an offence which is bailable, and it was offered to him that if you are ready, like section 50 of the NDPS Act, the offering that you have a right, mandatory right, that you should be, if you want, you can be searched in presence of a magistrate or a gazetted officer, whatever it may be. Similarly, in this case also, police has to offer him and said that you see that this is a bailable offence. If you are ready to furnish bail bond, you will be released. If you don't do that, that is, detention would be not in accordance with law. That is, therefore it will hit article 21. Similarly, after arrest, section 57, and there are other provisions that you have to produce the accused within 24 hours. He has to tell the grounds of arrest. All these things. These are also the procedure prescribed in CRPC. That if any of the provisions is not complied with, then it will hit article 21. Because whatever action has been taken by the police, that is not in accordance with the procedure prescribed by the law. I am clear? Right. Next, you come to article 22. Here once again, what I said, that what have been already incorporated in the CRPC is also here. No person who is arrested shall be detained in custody without being informed as soon as may be the ground of such arrest, and shall he be denied the right to consult or defended by a legal practitioner of his choice. So there are two things. First of all, the police is under Article 22, police is to tell him that the ground of his arrest, and to permit him to be defended and to consult a lawyer. If he said that I want to consult a lawyer, police is to allow him to talk to the lawyer. And then during the trial, to be defended by a lawyer of his own choice. You see, except in one case, if respect of one of the accused in Mahatma Gandhi's murder case, except the Nathuram Godse, all others, Apte and Bir Savarkar, all are defended by the lawyers. Only Godse said that I don't need service of any lawyer. He himself in 313, he have said that why he has killed Mahatma Gandhi. Similarly, in all other cases, in Indira Gandhi's murder case, the Jethmalini defended the accused persons. There are so many, Rajiv Gandhi's murder case and many other cases where the leaders of the top leaders of the countries were killed. In those years, this in Bihar, in L.M. Misra's murder case, all these things, and there are many cases. They have the right to be defended by the lawyer of choice. And here also I should refer at this stage only that if you are unable to get the service of a lawyer, suppose you are very poor, but with thus you are moving with some ideology. You thought that this leader who is propagating this kind of ideas is not for the poor, so he killed. But he is a ideologist, he has no earning, nothing. Have you seen the previously many freedom fighters, how they have led their life, not the present political leaders? So they have no fund, so how they should be protected? That is the reason 39A has been brought into. That if he has a no lawyer, it is the duty of the court that you have the right to be defended by a legal aid, to provide him the legal aid. And I will request you, all of you, if the accused is brought to you, if you find that he has no lawyer, as you have already told in the other case training program, that you have to offer him that if you want a lawyer, we can arrange from the this panel of the lawyers. And depending upon the, and not only the lawyer, you see the section 39A, one second. Free legal aid by suitable legislation. Then now it is a legislation, not only a lawyer legal aid, but a lawyer having good practice or having sufficient knowledge, not XYZ. The junior who has just enrolled for 2 years, you are as a part of legal aid, you are engaging him in a 302 case. So there you have to find out a senior lawyer, but may not be that in the panel may not be a good lawyer is available, or they are not taking interest, that might be. So this is very important, right, to be defended. First of all, to know the ground of arrest, and next to be defended by a lawyer, a legal practitioner of his choice. Next one is this: every person who is arrested and detained in custody shall be produced to the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for journey from the place of arrest to the court of the magistrate. No such person shall be detained in custody beyond said period without the authority of a magistrate. right? So it is also in section 57 or what, na, CRPC. Just look into it, find out what is the section that no accused shall be detained in custody without producing before the court more than beyond 24 hours. 57, no? Right. So therefore, if a police officer without producing him before the court of law detained in the police station, he can also be charged for wrongful confinement. 341 IPC possibly, the wrongful confinement. Because without any authority, he has been detained, confined. So it is another protection that he should be produced before the nearest magistrate within 24 hours. But it is said that 1 and 2 will not apply in a case of a enemy, alien, and any persons who have been arrested under Preventive Detention Act. That is MISA and other. Presently there is no such act, but previously Prevention Detention MISA was there. Next is this: even though in those cases where the a person is as you know, in preventive detention, this is an executive order. Joint Secretary of the Home Department in central government, they used to issue the order of detention for firstly for a period of 3 months, then after other formalities it may be extended up to 2 years. But this is without trial. During emergency and other times, the preventive detentions law are utilized by the these executives. So here also there are certain duties. That no law providing preventive detention shall authorize detention of a person for a longer period than 3 months. As I have said, unless an advisory board consisting of persons who are or have been or are qualified to be appointed as a judge of this High Court has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause of such detention. So therefore, board has to record a reason that there are sufficient cause of detention. And such person is detained in accordance with. When any person is detained in pursuance of an order made under law providing for preventive detention, authority making the order shall as soon as may be communicate to such persons the grounds on which the order has been made and shall forward him at the earliest opportunity to making representation against the order. As a lawyer, I had the occasions to appear in, I was assisting my seniors in all Kofe Posha case, this Prevention of Smuggling Activities Act. Now that is there. So in those cases, the grounds of, we took that ground that delay in informing the detainee about the ground of arrest, not disclosing the reason for his arrest, or they are relying upon, suppose they have relied upon a document and that relying upon document had not furnished to be, the order of detention was mechanical, all these things. Just I am telling you. So therefore, so far as the safeguard are concerned, I think that I have ended it. You just remember that article 20, 21 and 22 are very important, and in addition to that 39A. This is not this is also a kind of safeguards, because it is the whole object of it that to ensure that no accused is remain undefended, but he should be defended by a good lawyer. So these are the first part, the constitutional safeguards. I am making it short, otherwise if I go on then I cannot be able to finish it within the short time. Next is this, what is the program chart? parameters and conditions, special provisions on bail. So the that I will, when I will talk on these judgments, I will cover many things, but before that I will refer you few short things. And I am also sure that you have already posted with these positions of law. Just I am to remember, I am in fact I am playing a role of a medical representative. He is coming to the chamber of the doctors and just reminding him with some brochures that these are the medicines, this can be used for the purpose of this disease. Doctor already knew. You know, or each of you know what is the law. I am just reminding you, this is the law, it is for your information. 1 second, I am just reminding you. As the medical representative is telling the doctors that this is a paracetamol, it can be used in fever and these things, but we have this our company is manufacturing under the brand name is Crocin or whatever it may be, Calpol or whatever, Pyrigesic anyway. So, confused that I am teaching you anything. I am not teaching you anything. I am just sharing with you what is the position and just reminding you that keep yourself alive with all these things. Much time is necessary to cover the entire subject. At least few hours. Otherwise, suppose what are the parameters of granting bail? You are fully aware about that. First of all, the nature and gravity of the offence. Once you get an application for bail, you have to look at the sections, penal sections. What are the offences? So from that you will understand the gravity of the offence. It is a case of murder. That is the nature and gravity of it. You will find this is a case of causing grievous hurt, but not using any offending article 324, non-bailable, or 326, 307, serious offence. But what is in course of fighting in two groups, I hit you with a sharp cutting weapon. This is on the head. These are very vital parts of the body. So therefore it is an attempt to commit murder. But 307. But in course of altercation, suppose your two families were there to having water from the water tap. So the female members started quarreling with each other. The male members are coming out and they started fighting. And in course of that fighting, one person has assaulted another. Maybe on the head, a vital parts on the chest or in the stomach with a sub-cutting weapon. This is, as you know, this will come under 308. So that is how you have to understand. But suppose in a sub-cutting weapon, I have not hit you on your head or anything, but maybe on the leg or in this forearms or not very vital parts. Then this is the nature and gravity of the offence. First parameter you have to check. Then severity of the punishment if convicted, in the event of conviction. That if he is convicted, he has to suffer minimum sentence of life imprisonment or death. So you have to be careful. First of all, this is 302, it's a grave offence. Next is this severity of punishment is this, that if convicted, he has to suffer a sentence of imprisonment of life or maybe sentence of death. Then very important thing is this, those are in the next half we will consider those things, that likelihood of absconsence, root in the society. That he has a family, he is all these other things, therefore he has a deep root in the society. So chances of abscondence is less because he has a family members only. But you have to balance. Mainly because the chances of abscondence is less, that will not inure the right of bail, because the offence was grievous and how the offence is committed was a brutal and it was a cold-blooded murder. So therefore you have considered it, you have to emphasize more on that, not on the chances of abscondence. Then if you released, the chances of tampering with the evidence, terrorizing the witnesses and deceiving the witnesses. Who are the witnesses? Suppose it is a case based on document, maybe the forgery of the court records. Serious thing. So in this case, the police has seized all the documents and there is no a witness, a person may be gained over, but the record cannot be. So record in the custody of the police. You find that his chances of abscondence is not there. He is an old man and he has a family, he has a wife, son, daughters and grandchildren and all everybody, daughter-in-law, son-in-law, everybody. So therefore, you will now see that why he should be detained. Because all records are seized in the custody of the police and record will prove his guilt. Therefore, and he has a deep root in the society. The chances of terrorizing the witness or that tampering with the records does not arise custody of the police. So chances of abscondence is also not very there. So you can consider the question of bail favorably. And another chance is that is the gaining over of the witness. That is also the same thing, dissuading the witness. And another thing you have to remember, that impact of release. Because you see, all the laws are not to protect the criminal, but to protect the victim of the offence. So that you have to keep in mind. Be liberal, no question. But at the same time remember that it is to protect. Suppose a small girl is ravished by a group of boys. Right, you have found that is all other tests are satisfactory, that no chance of abscondence, because the victim and his mother are the witness. There is a very little chance that they should be gained over, and 164 has been recorded. Still you have to think. Still, and all the medical reports are in the custody of the court. Still you have to think that what should be the impact on the society if you release those 4 boys who are charged for an offence of committing gang rape on a minor. Right? You can, in this regards, you can read one decisions. This is recent decisions of Judicial. EIR 2022. Supreme Court, page 1918. EIR 2022, Supreme Court, page 1918. You are provided with online, SCC online. So, madam, you are SCC online or AIR also available? Both. So you are finding out, trying to find out that judge's decisions, and also in SCC criminal it is reported. Jagjit. Reference is AIR 2022, Supreme Court 1918. I cannot hear you. You do not have mic. This is a very big auditorium. Let me tell you that what should, I suggest you, what should reflect in your order. One difference is this: in case of anticipatory bail, you have to consider those who are in session judge, you have the jurisdiction to consider 438. So you have to consider that whether the custodial interrogation is necessary. As you know, that is one of the question, because in your order you must say that after brief notes that in my opinion, no custodial interrogation is necessary, because already everything is in the hands and nothing to recover. Suppose a person has been killed and the recovery of weapon is not done, so accused come or any documents is required to be seized. So custodial interrogation is necessary. That you will understand it. Then what should be your approach? That you should not at this stage go on detailed examination of the materials so far collected by the police. That is the 161 statement. That is not necessary. Or elaborate documentation on the merits of the case. Suppose there are 2 eyewitnesses or 4 eyewitnesses. So everybody claimed that in our presence X was killed by these persons. Now what happened? In one of the witnesses said that hearing a row, when I reached to the spot, I find that X is assaulting Y. I also raised alarm. Then the accused fled away. In the meanwhile, Y came. Now Y is also claiming that in front of me X assaulted Y. That this assault took place. So you are going into the merits of the case. And you find that total 4 witnesses. First witnesses claim that in his presence the accused assaulted the victim. The other, according to his statement, after seeing that, he raised alarm. Then only raised alarm and the accused fled away. Then thereafter 2, 3, 4 came. 2, 3, 4 came. So 2, 3, 4 now, but by that time, but they in their statement claim that in their presence this person was assaulted. Now you find that so far as the first witness is concerned, he was examined by the police after 20 days of the occurrence. So this is one of the very serious lapse, because according to the principal witness, all arrived at the spot after the incident or assault was over, and the principal witness was examined after 20 days. Therefore, you have to enter into the merit. These are the matter of trial. But if we find that a victim was kidnapped by a boy, but find that she is a major girl, they came and produced the marriage registration document, and they said that we have married each other and we are staying peacefully. And you find that normal practice is this: if you go to a lawyer, he will not only implicate the boy, he will implicate the entire family, like 498. So in those cases, you might consider it is a good case for considering the question of bail, because girl has herself arrived before the court, her statement was recorded under 164, the document was shown to you that they have married according to the special, before leaving away, 6 months before, they have issued a notice under the Special Marriage Act that I propose to marry her, or she said yes, I also propose to marry him. And then witnesses, then after 6 months is over, marriage was registered, but thereafter, after that, before registration, they fled away and then got the registration done. So everything is all right. You cannot enter into their marital life. So you can consider you should be, if I am there, I will immediately grant bail. And now my practice was this: in case of the parents are getting involved, I have to check up. No boy will inform the parents and fled away with a girl. This is very unnatural practice, but may not be that it is not happened. And because you remember why I will ask you not to enter into the merit, because you have to remember that the trial is yet to start, and only during the trial it can be considered, not before that. And recording short reason is to remember to safeguard your decisions. So if the decision went to upper court, go to higher court, then they shall see that in the order there is an application of mind. This is not because the charges are very serious, therefore you have rejected. But you have applied your mind, considered everything, and now decide not to grant or to grant bail. Excuse me. And the reason should be very brief, in brief. Now, about the special laws, statutes. 37 of the NDPS Act. Here you have referred. And when in the second sessions, we'll consider the other decisions, the decisions of Antil, Siddharth. There will, in Antil's case, you have, all of you have seen the decisions of Antil. What you have seen in the first two paragraphs, that Supreme Court has first said categorize the offence, category A, category B, category C. They are said how to approach. Category A are those offences nor punishable not exceeding 7 years. Category B, other offences exceeding 7 years. Category C are the economic offences. Category D, offences under special statutes. So, all those things to be covered when I will deliberate on Antil's case. And tell me why you have referred about POXO. So, who has done this thing? That these are to be, on this issue, this has to be delivered. Can you tell me?
Director.
Director. So, might be, as I feel, that POXO may be due to the Aparna Bhatt's case. So, that is in the second part. So, repetition is not necessary. Now, 167.2. As you know that the bail, you will find in CRPC in various provisions the word bail has been referred. Can you show me that where bail has been defined? Bail has not been defined anywhere. Just check up and tell me. I am giving you time. Ashim, 1 minute. Before that, I am telling you few cases where the bail was granted and where bail was not granted. Right? You just carefully note it. In one case, The accused was in custody for 6.5 months. Charge sheet submitted, co-accused standing not on same footing, on almost similar footing. He was granted bail and the accused has no criminal antecedent. This is a case where bail was granted. Similarly, a foreign national who is found to be the kingpin of the conspiracy. So, bail was urged before the Supreme Court on the ground he should have the special treatment because he is a foreign national. Supreme Court said no, because he is the kingpin of the crime. Now you see that this all cyber crimes, these phone calls, the Nigerian peoples. Then another is thing, you would note down of another decision, Daktaram Singh versus State of UP. It is reported in AIR 2018, Supreme Court 980. Also reported in 2018, 1 SCC, Criminal 675. Another in 2018, 3 SCC, page 22. 2018, 3 SCC, page 22. Important paragraphs are 3, 5, 6, 16. In one case of Gurbachan, here also the accused was granted bail almost 9 years after, because he is in custody but trial was not over. And this is not a case of 436A, not covered by Bhim Singh. The decision here is this. This case which I am referring is Haidar Jaidi. This case, what happened? The person was charged under 302 and he was a police officer accused. So bail was opposed on the ground that he is a very influential person and highly placed in the administrative capacity. So therefore, if he is granted bail, there are every chance he will influence the witness and manage the case. But Supreme Court found that few witnesses were examined, but the trial was not completed. But Supreme Court found that that 19 months already over. But I'm sorry, only a charge has been framed, but not a single, there is no further progress in the trial. Therefore, the question on the opposition that he was a police officer and if he is released on bail, there is every possibilities of influencing the witnesses and gaining over them, cannot be a ground for his detention, because investigation is over, materials have been collected, a charge has been framed, that even after framing of charge, 19 months have been elapsed, that is more than 1.5 years, till not a single witness have been examined. Therefore, Supreme Court in that case granted bail. In another case I find where it is a case of the entirely, as I am telling you, based on documentary evidence. Bail was granted because investigation was found complete and the properties of the accused, that those have been purchased, those have been so you are on that side corner, you just move it. I remember him, he was there on the last occasion, no? Yes. Hey, send somebody, একটু ঘুরিয়ে দাও না বাবা, ওকে দেখতেই পাচ্ছি না। He was there last occasion. She is here. Oh, you know. So Supreme Court said that all documents have been seized, documents, relevant incriminating documents, and there is no likelihood of absconsion and influencing the witnesses. Therefore, the person, and the more important is this: property purchased by cheating, ill-gotten money, by the what you said now in money laundering cases, proceeds of crime. You are aware about the money laundering cases, prevention of money. Here you have been facing any cases of prevention of money laundering? Thank you. I remember that under the Prevention of Corruption Act, the Chief Minister of Sikkim, that is a famous case. You know, he was prosecuted here. But that time money laundering, prevention of money laundering was not there. Suppose what is happening, that people are getting the ill-gotten money, depositing in the bank, disclosing in his income tax return, paying taxes, as telling, raising the hands, I am safe. But according to the Money Laundering Act, when the what the officers they are called, enforcement officers will conduct the raid, they will ask you to tell the source of the money. They will take a check period. It is the practice of the CBI previously, now that 10 years. During 10 years you are working as a officers in a particular government organization. You are earning about 50,000 per month. Therefore, what is your earning? Total earning. Then you have earned bank interest of this much. They will add it. Then we will find that you have a daughter and a son, and they are all sent to study in that convent school. And behind their education, you are every month you are spending this much of money. Out of that, now they had calculate what would be the available money with you. So you have found that you have two big houses in the city of Calcutta and flats, 2 crore, and you have the habit of suppose I am telling you to another case, that from there they will find out the disproportionate assets. Might be in the last 10 years you have been, actual income is this, that 12 lakhs. And out of that you have spent for the education of your child and other things. You have visited this state and that state, all are documented. Because I have come here in Calcutta, from Calcutta to Sikkim. That record is there with the airport authority, airlines. Ticket was booked. So everything is on record. Similarly, the former Prime Minister, Finance Minister and Home Minister of India, he was arrested. Before arrest, on 45 occasions, he appeared before the investigating officer for interrogation. Chidambaram appeared. At that point of time, he was aged about 74 years. And during in police custody, he was taken seriously ill on a number of occasions, and all the time he has to remove to the hospital for his treatment. So after days detentions, months detention, he renewed prayer for bail, rejecting, come to the Supreme Court. Supreme Court, considering all this aspect, that he made himself available for about 45 days, occasions, for his interrogation. And he is an old man of 70 and deep rooted in the society. His bail was granted. Only on this consideration. it has happened that the court granting bail saying that this is a case based on circumstantial evidence. But it is not that. Merely because a case is based on circumstantial evidence, therefore the accused is not entitled to, cannot be the sole consideration for granting bail to the accused. There are various other considerations. Only on that basis, because if you say that, you have to see that whether chain is complete or not. Suppose a person is found lying dead in a hotel room or in the house, a lady, old lady, and there are evidence that on the last night, in the morning her dead body was discovered when her maid came. On the last night, the one person, accused X, came to his house, and some neighbor says that that accused was her distant relations, that she was found alive because she was opening the door for the last time in the company of the accused. She opened the door and the accused entered and then closed the door, shut down the door. And thereafter, she was never found alive. So, it is within the special knowledge of the accused that how she died. He has to explain. So, first of all, a lady was found dead. On postmortem, it is found it is a homicidal died due to homicidal injury and antemortem in nature. Secondly, accused she was found alive for the last time in the company of the accused. Accused has no explanation how she died. Then from the accused came and she was found dead in her bedroom. Police collected chance fingerprint from the bed sheet and others, and that too also matched with the fingerprint of the accused. And asking you to give your fingerprint will not get an immunity under Article 20, that you are incriminating yourself as it is have to be given. So it has also matched. Then after interrogation, accused and that accused also led police party, but she was killed by strangulation to discover the rope, this thing. And then police discovered that there was some dispute going on over the property. These are the things, almost the chain of circumstances is complete. So now, merely saying that this is a case of circumstantial evidence, court should not grant bail. And in case of contact killer, sharpshooter, hired killer, you will find in many cases I have seen that hired killer are engaging for killing the victim. Those are the cases where court should think twice considering the question of bail, while considering the question of bail. Something about 167, because there is also reference about 167. That one decision of state of Ashim versus Rakesh something. This is on 167. As you know, there are kinds of bail are Rakesh Kumar Paul. Yes, this one. Just scroll up. Come to this is a 3 judges bench decisions, and the Justice Lakur Pasivili and Justice Deepak Gupta gave the concurrent view, and Justice Prafulla Pant take a different view. So come to the conclusion of Justice Deepak Gupta. Yes. No, this is the conclusion of you see paragraph 29. The court in a large number of judgments has held the right to legal aid is also a fundamental legal right. And legal aid has to be competent legal aid, and therefore it is the duty of the counsel of the accused, whether they are paid counsel or so. 1 minute, I will come to that. In my view, the magistrate should also not encourage wrongful detention and must inform the accused of his right. That is what you are pointing out. This is that decision. This is the latest decision on the point. Anyway, I have left the note, so therefore but it comes from the record that accused lawyer verbally said that 90 days is over and he has not get bail. Supreme Court said this is also enough. Therefore, when Supreme Court said it is enough, this is a binding precedent. That means that accused may not have to file a formal application. Even if he says that orally that I have today the 90 days is over, no charge sheet has been filed, can be statutory bail. This is sufficient. Now on sessions 2, the judgments on Kumar and others. First start with Hon'ble Kumar. If you see the judgment, you will find that it composes of 2 parts. First is on 41 and another is 41A, and then it is quoted in the judgment. Madam, both 41 and 41A is quoted in the judgment. I am coming to that. Yes, para 7. So what you found? So, two things before I start with, I may tell you two things. That this is on the reference to 41 and 41A. And in the judgment, there is certain direction upon the police and there are direction on the court. We are essentially concerned with the direction issued against the court. So what is 41? 41 deals with the offences where the maximum sentence of imprisonment not exceeding 7 years. Alright? So what they said that you see in 41 II, the police officer has to be satisfied on few points. What? That prevent such person from committing any further offence or for proper investigation of the offence, to prevent such persons from causing evidence of the offence to disappear or tampering with such evidence in any manner, to prevent such person from making any inducement, threat or promise to any persons acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer, or as unless person is arrested, his presence in the court whenever required cannot be ensured. So therefore it is incumbent upon the police when an accused is before him, who is against whom the case has been lodged relating to the offence where punishment is not exceeding 7 years, before effecting any arrest, to record his satisfaction. Right? And also in last proviso you will see that if a police officer decides provided that a police officer, have you got the line? Provided that a police officer shall, in all cases where arrest of a person is not required under the provisions of this section, record reasons in writing for not making arrest. So, police officers have two duties. If we want to arrest the persons, to record the reason that have been delineated under clause B, and if not want to arrest, according to this proviso, he has to record reason and to communicate his, convey it to the magistrate court. Where the section 41 is reproduced. Here it is said, last para, proviso, that a police officer shall in all cases where arrest of a person is not required under the provisions of this section record the reason for not making the arrest. Now, So come to 7.3. Omit first 4 lines from the top, then come to right hand side. Before arrest, have you got it? Before arrest, first the police officer should have reason to believe on the basis of information and materials that the accused has committed the offence. Apart from this, the police officer has to be satisfied further that the arrest is necessary for one of the more purposes envisaged by subclause A to E of clause 1 of section 41 CRPC. So this is the duty incumbent upon the police. We were looking at it, but still we are more concerned with what is the duty of the court. And this is what I have told you about 57A while I am addressing you on the scope of article constitution, and that is 24 hours. So this 8.1, it is the duty of the court. So during the course of, only when it is authorized by magistrate in action, the power to authorize detention is a very solemn function. It affects the liberty and the freedom of citizen and needs to be exercised with great care and caution. Our experience tells us it is not exercised with the seriousness it deserves. In many cases, the detention is authorized in a routine, casual and cavalier manner. So next is very important. Before a magistrate authorized detention under section 167, he has to be first satisfied that arrest made is legal. Therefore, he has to draw, wherefrom he will draw satisfaction from the report that the police has satisfied that the case for committing the offence has been made out, and then satisfied the arrest of the accused is necessary as in terms of the various other clauses delineated thereafter. Right. Magistrate, now again on 8.3 is the duty of the magistrate. Just see that 8.2, that the magistrate is duty bound not to authorize his further detention and release the accused if he find not satisfied with the requirements of section 41 has been considered by the police. Then 8.3, magistrate before authorizing detention will record his own satisfaction, maybe in brief, but the said satisfaction must reflect from his order. It shall never be based upon the efficacy of the police officer. For example, in a case considered the arrest necessary to prevent such person from committing any further offence or for proper investigation of the case or for preventing an accused from tampering with the evidence or making individuals so and so. Those shall be perused by the magistrate while authorizing detention only after recording this. Therefore, the police may record all these things. That is not sufficient. The magistrate by himself has to record his satisfaction also. So another 8.4, the almost same thing. The magistrate has to address the question whether specific reason have been recorded for arrest, and if so, prima facie those reasons are relevant. Secondly, reasonable conclusion could at all be reached by the police officer that one or more conditions stated above are attracted. To this limit, extent magistrate will make judicial inquiry. Now, it is, the court has come to consider 41A CRPC. That is, now you are regularly came across that the 41A notice has been served or not. The aforesaid provisions got, this line starts with the words it clear that in all cases where the arrest of a person is not required under section 41(1) CRPC, police officer is required to issue notice directing accused to appear before him at a specified place and time. Law obliges such an accused to appear before the police officer, and in further mandates that if such an accused complies with the terms of notice, he shall not be arrested. Unless reason to be recorded, the police officer is of the opinion that arrest is necessary. You think that the aforesaid makes it clear that in all cases where arrest of a person is not required under section 41(1) CRPC, the police officer is required to issue notice. So, in my perception, that police has already reached to a conclusion that in the light of whatever has been set out in various clauses A, B, C, D, that arrest is not required. So still he is required to issue notice directing the accused to appear before him at a specified place and time. Law obliges such an accused to appear before the police officer, and it further mandates that if such an accused complies with the police of complies with the terms of the notice, he shall not be arrested unless for reason to be recorded. Police officer is of the opinion. So already I am asking myself, the police officer already come to a conclusion in terms of 41(1), the arrest of the person is not required. That is why he issued a notice under 41(a). Now the accused appeared before the police officer. Now Supreme Court said that in that when he appears, that if such an accused complies with the terms of the notice, he shall not be arrested. So he will not be arrested unless for reason to be recorded, the police officer is of the opinion that the accused is necessary. I am emphasizing on this line. Unless for reason to be recorded, the police officer is of opinion that arrest is necessary. Already police officer has come to a conclusion that arrest is not necessary. That is why notice under 41(a) has been issued. Therefore, after arrest of the appearance of the accused, so it is for the second time police has to decide. What is your opinion? Read carefully and tell me.
The notice and the person appears, then it says if the arrest has to be made, again 41 has to be complied with the conditions in 41. So
why?
Such a
Because
situation,
already
yes, Lordship.
police officer has applied his mind.
Yes.
He said that he is recording the reason that offence has been committed. He said that the arrest is not necessary.
Yes, Lordship.
If he take recourse to clause B,
Yes, Lordship.
then he should notice. Accused came and attended.
Yes, Lordship.
Then again he has to reconsider.
But in the meantime, Lordship, the accused might be influencing the witness, tampering. Circumstances might have changed. Facts might have changed also during such time. And that would be...
So he has to review his decision.
Yes, Lordship, because the judgment says that again 41 has to be...
So that is I am asking myself. It is not very clear to me.
Lordship, there are these, at the beginning of the last sentence, there are these words. At
1 minute.
stage
At this stage,
also.
which line you are referring to?
So third last. So at this stage also. So I think
At this stage also, the condition precedent for arrest as envisaged under 41 CRPC has to be complied with. So therefore, once the police has come to the conclusion, arrest is not necessary. After his appearance, police once again consider it necessary.
also.
So you tell me, under what circumstances police has already said, suppose you issued under 204 you issue summons to appear, accused appear. So what you will do? It is little bit confusing. Anyway, with great respect to the Supreme Court's decisions, I'm just not clear very much to me.
Lordship,
Speaker, mic.
Worship, these few lines at this particular paragraph, I think this has been copied from 41A, where the law requires and provides that where it is necessary, the police can arrest. So it is just the copy of that 41A. which
No,
has been-
you see, this is not the section which has been copied and pasted.
Not section, but the last provision which Lordship is reading. If you
No,
read-
I am saying it is the concluding part.
Yes.
Because you see, the aforesaid provisions makes it clear.
Lordship, if you read 41.
1 minute, you look at the judgment.
Yes. I cannot read it very well.
You just look at the judgment, then come to the section.
Lordship, such a situation may arise. Notice is issued under 41A for the accused to appear maybe before the police station to investigate the case. During such time, the accused may influence the witness, or the accused may
No, that you have said. It may be such an occasion.
So such circumstances can happen.
Such an occasions. Because might be when it was the 41A, that 41A notice was issued, that time it might be it as an offence under 326 or other things, or 7 years punishment, 325 or that. But thereafter it is found that when he appeared, it is a person died. Is it such a situation referred here?
Because Lordship, unless there is a change in the section 41A clause 3 itself, Lordship, I think what the Honorable Supreme Court has mentioned here,
You are referring which part?
section 41A clause 3, Lordship, if you read CRPC, it is the same sentence which is pasted there.
1 minute. Here it is also quoted. You see, here 41A, the police officer shall in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41, issues a notice directing the persons against whom a reasonable complaint has been made or credible information has been received, or a reasonable suspicion exists that he has committed cognizable offence to appear before him at such other place as may be specified in the notice. So, 2. Where his notice issued shall be the duty of the person. Where such person complies with he shall not be arrested in an offence referred to him unless for reason to be recorded, which is of the opinion that he ought to be arrested. So you are saying that this word ought is important. Because see that already police officer in terms of section 41 come to a conclusion that he is not required to be arrested. So he issued a notice under 41A. Now after his appearance, there are other materials that makes the word ought to be arrested. Am I clear? So job is very tough. Once on considering the materials, you said that he need not be arrested. That is why you issued a notice under 41A. Now he appeared, compliance in response to that notice. Now you are saying you are reverting your position. You are saying, no, he ought to be arrested. You think over it and give me some examples where if you in the place of police officer, under what circumstances you could have said that the accused ought to be arrested. After coming to the conclusion that it is not necessary to be arrested. Give me one example. You think over it, all of you.
Lordship, if new facts come in.
I think if new facts come in, the police officer gets to know about some new fact that he did not know before about the case or the first information or the
No. Police officer already posted with the facts and everything. Then decided not to arrest. Issue 41A. Now, after he appeared, then police officer come to the conclusion he ought to be arrested. What is the legislative intent behind it? We now need to see when these provisions is brought into the statutes book in the parliament or the lawmakers. What is the object of the lawmakers to bring it this provision? 41A is an amendment. Previously it was not in the statutes book. You see when 41A has been introduced? Find out. 2010. Previously it was not there. But therefore, legislature in their wisdom decided to introduce these provisions. So what is the object behind it? Because once the police has considering all the aspects in terms of section 41 decided not to arrest. Right? He will not be arrested. Now, by virtue of 41A, deciding not to arrest is not enough. Despite coming to such conclusion, police is to issue notice. Just see, the police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1, issue a notice directing the person against him. Now you will get time, think over it. It is a thought evoking. Why this has been introduced. Now, so in paragraph 11 and thereunder, the Supreme Apex Court, the Hon'ble Supreme Court has set out its conclusion, final conclusion, which was already there. Now, for the sake of convenience, it has been set out in a shortest form. Right, but it is, have you seen here, there is any direction that we are considering the question of bail? Is there any indication that if not complied with all these things by the police, that you should be released on bail? Check out. Tell 8.2. You are on 8.2? Yes. First line. Before magistrate authorized detention under 167 CRPC, he has to be first satisfied. Then the last line. Is to be satisfied that the condition precedent for arrest under section 40 has been satisfied, and it is only thereafter he will authorize detention of the accused. It is in negative said that when he can authorize detention. So therefore, if it is not satisfied, he will not authorize to pass an order of detention. He will not authorize detention. So if he doesn't authorize detention, he has to release the accused on bail. That would be the only logical conclusions. Are you agree? Tell me, if you don't agree, tell me, don't, I am not agree. I don't agree.
Lordship, I feel here the police have come before the magistrate for extension of the police custody.
No, not police custody. Suppose police has complied with 41. Thereafter issued a notice under 41A. Accused came before the police. No, first cases of that where police has not complied with the 41.
Yes, Lordship. So
1 minute. Then the accused is arrested and produced before the magistrate. This is one kind of case. And in another kind of case is this: 41 has been complied with, 41A has been complied with, then again taking recourse to 41 and in terms and the requirements of the clause B, the person was arrested and produced before the magistrate. There are two kind of cases. Now tell me.
yes, Lordship. So the police in this cases will file an application for extension of police custody beyond 24 hours.
May not be police custody. It may be for remand.
Yes, Lordship.
Maybe in police remand or to judicial custody.
Yes, Lordship. So out here, if the conditions are not fulfilled, then we may reject the application for police custody or judicial custody. So automatically the police will have to release the person after 24
No,
hours.
unless
Within the
how
24
police will
hours.
release? You have to pass an order of bail.
Lordship, here my understanding is we are rejecting the application for PC or JC.
That doesn't mean that you will be released on bail.
So beyond 24 hours, since there is no order for extension,
No,
the
no,
police
no,
will have
no,
to
no. What do you
release
think?
Release.
What is your opinion? According to he said that when the accused is produced before the magistrate found that 41 and 41 has not been complied with. And according to the ratio of the Supreme Court decisions, that magistrate will in this case will not authorize detention. If he doesn't authorize detention, what is the course available to the magistrate? An accused is produced before you. You said that you have not complied with. I will not say detain. I will not detain. Is it so? No. You have to pass an order of bail. Because it is an admitted position. He is found that he is a prima facie. Just see what is the first line of 41. Against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he committed a cognizable offence punishable with imprisonment for a term so and so. So trial is necessary. What is bail? That is what I am trying to tell you. That bail is not a defined word. In various provisions of this code, you will find the reference of bail. But what is actually bail? Bail means you are giving an undertaking by furnishing sureties that you will be available for during the trial or whenever court issued summons to appear.
So, Lordship, in this case, do we require him to furnish surety or will it be on plea?
No, that you decide. It depends. You can peer bond or you will ask for sureties.
Lordship, what
Lordship, what I have been generally doing with regard to these cases is I direct the investigating officer to forthwith release the accused on his production of surety and furnishing a bond. So that is what I write.
This is in case of bail, what you direct? While you are granting a person bail? Huh?
In my understanding, I am releasing the accused because he has not been granted remand.
You are asking the police. What you are asking? Repeat.
I direct the police officer to forthwith release the accused on bail, bond.
On
On
furnishing
his
a bond. And if you otherwise, you will decide, even if everything is okay, to release the accused on bail. What order you passed?
Similar with conditions.
So what condition? You will not say simply that let this accused be released on bail on furnishing a bond of rupees 2 and so on, without sureties or one sureties of or two sureties of 2,000 each, or one sureties of 5,000, or on PR bond. The same thing you are directing. But see, now he is not in police custody. He is in judicial custody. When he is present before that, you will come to when you will find the case of Siddharth. There it is said that about 170, that the court is rejecting the bail, saying that issue non-bailable warrant of arrest. Why? Because these are the offences where are non-bailable. Court said that that you charge sheet submitted, but I will not entertain charge sheet because you have not arrested him. So therefore non-bailable warrant of arrest be issued. So their court interpreted the custody. Custody said police custody, judicial custody, or appearance before the custody. As soon as he appeared before you, he is in your custody. So you are releasing from your custody.
No, sure. I have a small query.
Mike.
Lordship, I have a small query. If we are saying that the arrest is not warranted, if the police, the arrest is not required and is not necessitated, but by releasing the accused on bail, are we not justifying the arrest then?
No. You see, even in case of a bailable offence, so even if arrest may not be, what is arrest? Taking a person in custody. In case of bailable offence also, a person to be, police has the power to arrest. If the offence is a cognizable offence and it is bailable, can the police cannot arrest? So when he is arrested, the accused is arrested and produced before the court. Court found that all the this 41A the different this thing has not been complied with. Therefore, police has not rightly arrested, but it was produced before the court. Court can merely say you go. But their case is made out, a complaint has been lodged. But you just see that it is 41A never said that only when can be released if found that no case has been made out. Can at that stage court come to the conclusion? It depends on the trial. But you see the once again that these are the things to prevent such person from committing any further offence.
Lordship, can I explain through personal practice what because I have been doing? Most of the time, in case of heinous offences, generally it was I would give an extension of remand. Most of the time, arrest is also made. But as a magistrate, we mostly deal with not very serious offences. So in such cases, what the police does is, if they find that the interrogation is complete and they do not find any reason for the accused to be further remand, detained in the police custody, then they inform us through such an application only, the requisition which they make before us. So at that stage, what as a magistrate I've done is that we've given them legal aid and then asked the accused person to file for bail and immediately release them.
This is the right thing. Remember it. Police has produced it, the accused in your custody, produced before the court. Therefore, he is in your custody. So what she is saying, that she is passing an order directing the police take bond from him and release him. He is no more in police custody, he is in your custody. Therefore, what you are directing police, instead of that, you pass an order saying that the accused now be released on bail on furnishing so and so securities or worth of rupees so and so. That is to be the correct approach, as I understand. But now I see this is I am not sitting in appeal over your judgment and deciding the question and delivering the judgment, saying that what is your wrong and what you should do. Here we are interacting ourselves. So there, it is your prerogative to decide the question by yourself, not where I am telling from my chair here. You are not bound, and I will not go to tell you what you should do. I will only discuss and interact with you to evoke some thinkings in your mind, what you should do and what you should not do. Please remember, I am not telling you anything to do. I am just discussing and interacting with all of you. Sharing and exchanging our opinion, what we should do and what we should not do. But keeping it in mind, you will now decide that in such a situation what you will do. Ask what she is doing, that police to release on bail, you will do that. Or what you are doing, that considering every other, this is a case for releasing on bail. Accordingly, he is directed to be released on bail on furnishing a bond of sense. That should be final.
There is one more situation as magistrate we've seen.
Listen, not here. Just on
There
it.
is one more situation, Lordship. In case of very small offences, not very serious offences, the police without arresting, they release the accused persons in the police station or on police case.
In spite of that, it is a non-bailable offence.
No, most of them are bailable offences.
Huh?
Bailable offences.
In a non-bailable offence.
No, Lordship. Bailable offences.
So, if the police in a bailable offence release an accused from his custody, they have committed nothing wrong.
Yes, Lordship. So these are the situations.
Nothing wrong. But how you will take him in custody if it is a bailable offence? Unless he violate the condition of bail.
Lordship may give some clarification in this. Normally, the person is left on police bail.
Huh? No, I can hear you. Just raise the volume.
The accused is left on police bail, and after charge sheet is filed, the accused appears and they file for bail. Now, I think there is a Supreme Court judgment again saying, do not ask for bail from the accused. Do not insist on bail.
No, please, sir. Supreme Court has never said that.
Just recently.
What Supreme Court has said? Supreme Court has said that it is what court is doing. Court is saying that no, I will not accept the charge sheet because accused is not, you have not arrested. Issue non-bailable warrant of arrest. Supreme Court has said that you did not have to issue non-bailable warrant of arrest. Custody, court has to be produced in custody. Custody is police custody, jail custody, and we will come to that decision. That is in Siddharth case. Supreme Court has never said this. So this is over. No? Now we come to the Siddharth. Because this Bhim Singh is on 436A. Madam, Bhim Singh is on 436A and Aparna Bhatt is on condition of bail. We will come later. Okay. Now let us come to Siddharth. Siddharth. Tara. No, first of all, para 2. You just see what is the issue involved. Para 3. You are looking for 170, madam. Looking that next pay para is 170. So what is the said? What is the issue involved? Police completed investigation, submitted charge sheet, but court declined to accept charge sheet because he said that in terms of section 170, you have to produce the accused before me. So issue non-bailable warrant. So that was the controversy. Now in para 9, Supreme Court has resolved the controversy. So let us come to para 9. Am I clear? Clear?
Not observation, actually just an input about how we do it, Ashim. At the time of filing of the charge sheet, we never required the attendance of the accused. It is only at the time of the first appearance of before the court that we require. And for that we sent summons.
For that?
We sent regular summons.
Regular?
Summons.
You write?
Yes, Ashim.
No, let me tell you. What you write? Receive charge sheet in connection with so and so case. It appears from the charge sheet that these are the person arraigned as an accused. It is further found that they were never arrested, or they are never arrested, not on bail. Right? Maybe he is on anticipatory bail. Let so and so date be fixed for their appearance. Issue notice accordingly.
And if they don't, if the accused doesn't comply, then the court is bound to issue NTWA.
No. No. Now we will come to the Antil's case. So you please, 1 minute. On that day you issue summons. If he doesn't appear, you have to issue bailable warrant of arrest. Even if he does, if you have to first satisfy that the summons have been served, service has been directly affected, then you have to note down that by my order dated so and so, summons was issued against the accused person fixing today for his appearance. But accused is not before us. Now, before that you will say, record reveals that summons has been duly served upon him. Still he is not before court. Issue a bailable warrant.
I'm sorry. It's a PWA.
This should be the language. Then again, after bailable warrant of arrest, if he doesn't appear, then you will say that the bailable is, since he was not, first we issued summons, he didn't turn up, we issued bail of a warrant of arrest. Although he has been bailable warrant of arrest has been executed, Still he is not turning up, so issue a non-bailable warrant of arrest. Now another condition, even after issuing of non-bailable warrant of arrest, if he didn't turn up, if he filed an application, and in the summons you have to say that either by yourself or through your pleader. That is the format. So you can appear. And after bailable warrant of arrest is issued, then also he has to appear a non-bailable warrant of arrest. Before the non-bailable warrant of arrest is executed, if the accused appeared before you and make an application saying that recall your non-bailable warrant of arrest and grant me bail, you have to do that. That is what in Antil's case has been said. This is developing. It is day by day developing the position of law.
Lordship, so if a accused appears to the summons, then there is no necessity of him surrendering and filing for bail.
No. How? One thing you are not understanding. What I am saying that every accused against whom there is a specific case registered, you have to release him on bail. Otherwise, how you release from your custody? He is in court custody. You have your criminal rules and order in your case, Sikkim. So you see the procedure prescribed. You have to release him on bail. You cannot say that you go. Police has not arrested or not, because case is there, charge sheet has been submitted. Police has sent him under section 173/70 for facing the trial. How can you release him without taking undertaking?
Yes,
What is bail? Taking an undertaking that he will appear. And in support of that, I stand surety. No, if he don't appear, I will get him appeared, or my bond will be forfeited. So therefore you have to grant him bail. Without bail, you cannot release any accused. As soon as he appears, he is in the custody of the court. Follow? You please also read para 10. Para 10. Fourth line is also important. No. Hon'ble Kumar. First, madam, first see para 3. In Hon'ble Kumar case, anticipatory bail was rejected, both by Sessions Court and High Court. Then he approached for anticipatory bail. See para 3. नहीं इतना बड़ा नहीं, छोटा से नहीं है, तब तो ये तो है ही मेरे पास. ठीक है, छोटा सा देखो ना, छोटा सा है ना, नहीं तो है उसको. ठीक है, देखो छोटा सा. Bail was rejected by the Sessions Court, then by the High Court. Now they have preferred as SLP, because you cannot come. Is there any provisions for filing anticipatory bail before the Supreme Court? So how do a person approach Supreme Court for anticipatory bail?
Especially petitions. Especially petitions.
Right.
Article 125.
Right. Come to para 14. What is said? So therefore, you are clear now? So bail has to be granted. You cannot merely release. Clear? Any issue? Madam, you have no query. You have no query. What Hon'ble Kumar reflects. Hon'ble Kumar was the husband, charged for 498 and dowry prohibition. Bail was not, anticipatory bail was not granted by session judge. He approached the High Court. High Court declined. Then he, filing 136, asked for anticipatory bail. So in that case, Supreme Court observed many things, and while admitting the special leave, he was granted provisional bail, which now after the conclusion of this decision has been confirmed. Therefore, whenever an accused appeared before you, in whatever way, you have to release him on bail. And he should be released from the bail bond when he is, you have to discharge from bail bond. Suppose in one case, person was not arrested. Police filed final report. You know what is final report? So then in that case, you never ask them to file bail. Because police itself, what you have the power. If you follow the bench case, you have three options available to you. You can accept the final report, or on the materials placed before the police, you may come to the conclusion that materials already collected by the police make out the offence, cognizance taken. Or you may cognizance taken, and you may accept the police report without taking cognizance and discharge. But before discharging, following Bhagavan Singh's case, or Bhagavan, I don't remember now, you have to issue notice to the complainant. And complainant has filed a Naraji petition. You know the terms used there, Naraji. Naraji petition is filed. Then you have to go through it. You can take cognizance on it and proceed against the accused. So therefore at that stage, no use of, if police file discharge application, you didn't take cognizance on it, and also that the accused de facto complainant appeared and unable to maintain the case, then you have to, what you will do? In that case, it is not required to ask the accused to furnish bail. But if he is already on bail, suppose before filing charge sheet, was one day anticipatory bail was granted. In the anticipatory bail, it was directed that you surrendered in the court and get the regular bail. He was on regular bail. You have to discharge him from the regular bail. And also remember one thing, that every sureties, registered sureties have certain amount of bail bond for 5,000. If he, in one case he furnished a bail bond to 1,000, it will come down to 4,000. And then in 2000, another case 2,000, it will come down to 2,000. 3,000 already furnished, and in the, it will be 0. But now he is, one of the accused is discharged from the bail bond, again 2,000 will come back. You have to see the criminal rules and order, the procedure. That is very important. Now we are left with only one decision, that is Until's case. in the two other decisions are there. So two other decisions are there, right? So in the two other decision is one is Aparna Bhatt and another is Bhim Singh. But now we see the Antil's case. In first paragraph, it has categorized the cases. Para 2. First, read the requisite conditions. It should be the starting point. Not arrested during investigation. Cooperated throughout in the investigation, including appearing before the investigating officer when called. Please keep it in mind. Now, Supreme Court has categorized 3 cases. Offence punishable with imprisonment for 7 years or less, not falling in category B and D. So it is category A. B, offence punishable with death, imprisonment for life or imprisonment for more than 7 years. Offence C, punishable under section Special Act, that is NDPS, PMLA, Companies Act. You know what is 122 or 212 of Companies Act? Anybody knows? It is
Transfer of shares.
serious fraud. This is a new amendment. There is also a stringent condition like 37. Note it and please look into 212(2) of the Companies Act. Note down. You must see it. Can it be 212? Can it be displayed here of the Companies Act? Investigation Office. So, I start with the requisite conditions. NDPS. And for serious fraud, no notification. Huh? Oh, no notification. But this has to be tried by the court, special court.
No, Lordship, we don't have Companies Act enforced in Sikkim actually.
Sikkim Companies Act is not applicable.
No, because we have our own local Companies Act under Article 371F, the Local Companies Act.
So in there are nothing like these provisions.
No.
So then we leave it.
Yes.
So there are, what I said that what are the requisite conditions? The not arrest during the investigation, cooperated throughout in the investigation, including appearance before the investigating officer whenever called. So Supreme Court has said 3 categories of cases. Category A, those are the offence where after filing of charge sheet, until para 2. Not arrested during investigation, cooperated throughout, in the investigation, including appearing before the investigating officer whenever called. Right? Acha. Category of offences. Offence punishable with imprisonment for 7 years or less, not falling category B and D. What is B? Offences punishable with death, imprisonment for life or imprisonment for more than 7 years. C. Offence punishable under special act containing stringent provisions for bail, like NDPS Act section 37, Prevention of Money Laundering Act PAVL section 45, UAPA Act, Unlawful Activities Prevention Act section 43D5, Companies Act section 212(6), that is a serious fraud. Right? So now we'll come to the next point, next line. Category A. After filing of charge sheet, that is to 170 on 170, and complaint taking cognizance. It should be after appearance, after issuance of summons. Ordinary, the summon in the first instance. Just listen what you are asking me. Ordinary summon at the first instance, including permitting appearance through lawyer. What I am telling you. Then if such accused does not appear despite service of summons, then bailable warrant for physical appearance may be issued. Non-bailable warrant on failure to appear despite issuance of bailable warrant. Then non-bailable warrant may be cancelled or converted into bailable warrant summons without insisting physical appearance of the accused, if such an application is moved on behalf of the accused before execution of non-bailable warrant of arrest. Therefore, he need not have to appear. If non-bailable warrant of arrest is issued, then before execution, if through his lawyer he filed an application, it can be recalled and ordinary summons be issued on an undertaking that accused to appear physically on the next date of hearing. Bail applications of accused on appearance may be decided without accused being taken into physical custody or by granting interim bail till the bail application is decided. Therefore, you are wrong in saying that if he appears, you will say that no, police has not issued warrant of arrest or not arrested, you go. You have to be released, the accused has to be released on bail. Don't commit this mistake. Achha, category B, this is on appearance. Suppose in a 302 case, not arrested, cooperated with the investigating agency, summons have been issued, he appeared, then the application for bail be decided on merit. Just look at that. And third category, that is our NDPS, that is same as a DD but compliance with the provisions of bail. Right? Now, you come to the thing. Read carefully. Three, last sentence. Read loudly, madam. What is that?
The courts will have to satisfy themselves on the compliance of sections 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail.
Yes. So, which line is important?
The second one.
Line, non-compliance should entitle the accused for grant of bail. Clear? That mainly because 41A and 41 was not complied with, you will say go. Not that. You will be entitled to bail. Release him on bail. Because case is there, still surviving. It has not ended in acquittal or discharge or anything. Just keep it in mind, madam. Then (105) important. Please check up in your books what is, I don't say, and to all the section 88, 170, 204 and 209. Please check up. 88. I think that you read, you will get your answer. When any person for whose appearance or arrest officer or arrest, the officer presiding any court is empowered to issue a summons warrant is present in such court, such officer may require such person to execute a bond with or without sureties for his appearance in such court or any other court to which the case may be transferred for trial. Clear? You cannot merely say you go. You have to take bond. Then come to section 170. This is about the where charge sheet is submitted. It is not need to be read. 204, it is also clear, summons issued. 209, commitment. Right? So, one minute. While insisting upon sureties, 109. Important for you. Section 440 of the code has to be kept in mind. Then 110. An exercise will have to be done in a similar manner to comply with the mandate of 436A of the code, both district judiciary level and high court as early as directed by court in Bhim Singh, followed by appropriate orders. Another thing very important for you, 111. That's all about this case. Come to Siddharth. Para 4. Provisions are very important. So it is not that it is automatic, that he has served out half of the sentence, because provided further, if the public prosecutor satisfied the court, his detention is required to be continued, then in that case court after satisfaction and pass order. And lastly, if he already served out the entire sentence, then he should be immediately released. Six, are you following this? Sitting in the jail, holding court there. Holding court. You did. Shall hold one sitting in a week. Court inside the jail. Are you doing? Doing? So face contempt of court from Supreme Court and disciplinary action. Apex Court is saying many things, but they are not thinking what is the they are giving mind that whether actually it is possible or not. How many but at least hold one or two court inside jail. So what they said? Such jurisdictional magistrate, chief judicial magistrate, session judge shall submit the report of each such sitting to the Registrar General of the High Court at the end of 2 months. The Registrar General of each High Court shall submit the report to the Secretary General of the Court without discord, without any delay. Ready to face contempt. Huh?
The word used is court sitting.
The judgment on the previous page, it specifically says that it is for the period of 2 months commencing from 1/10/2014. And a report
So you
of
are
2
saying, you
months.
are taking that defense that you have appointed thereafter.
No, Lordship. The judgment only says that
No,
One
judge
sitting.
shall hold one sitting in a week in each jail.
prison for 2
Prison
months
for
commencing
2
from-
months commencing from for the purpose of effective implementation of so and so.
Yes, Lordship.
Right? So when you have got appointment?
2014, Lordship. 14.
14. So,
Lordship
Nah.
on the next page.
and all of you 14 or before 14 or after 14? 14. After 14. So you only after 14. This is Bhim Singh. Now come to Aparna Bhatt. Para 3 read. Interesting part is where the order is reproduced. High Court's order. The applicant along, have you got that line? With his wife, visit the house of the complainant with Rakhi thread banned on 3rd August 2020 at 11 am with a box of sweets and request the complainant Sadda Bhai to tie Rakhi band to him with the promise to protect her to the best of his ability for all times to come. He also tendered rupees 11,000 to the complainants as customary ritual usually offered by the brothers to sister on such occasion, and shall also seek her blessings. The applicant shall also tender rupees 5,000 to the son of the complainant Vishal for purchase of clothes and sweets. The applicant shall obtain photographs and receipts of payments made to the complainant and her son, and the same shall be filed through the council for placing the same on record of this case before the registry. The apostate deposit amount shall not influence the pending trial, but is only for enlargement of the accused on bail. So see, such an order has been passed by the Madhya Pradesh High Court. So Supreme Court set aside and just see the conclusion. Para 44. Just see from A, read from A.
Many times where there have been many instances where I have specifically given the order that the victim should not be contacted by the accused even through social media or through phone.
Correct. That is what he had said. You are in charge of special court, POXO.
Ashim, I'm CJ. I'm CJ.
Alright? Everything is and for you I will give two decisions relevant about NDPS Act. This is one, Union of India versus Pratik Shukla. EIR 2021 SC 1509. And another judgment you can look into, that is NIA versus Jahud Ahmed Shah Watali. It is 2019 2 SCC Criminal 383. Right? So, finished.